Hello, I'm James Hutchinson, a partner with Beale & Company. Today I'm going to give you a whistle-stop tour of the General Data Protection Regulation, also known as the GDPR. The text of the regulation is about 90 pages long and contains 55,000 words, so I'll focus on some of the key issues which are of relevance to employers. Hopefully, I should only take up about 30 minutes of your time. As I go along, please feel free to ask questions using the box on your screen. If there's time at the end, I'll go through a few of those. Otherwise, I propose to anonymise the questions and circulate some answers to all attendees after today's webinar. If you don't want your question anonymised or shared at all, please indicate in the box. So, a few points to note. Whatever your views on Brexit, you may have all secretly hoped the GDPR would quietly disappear. But the government has confirmed that the UK will implement the GDPR from the 25th of May 2018. So you've got just under a year to get ready. The ambition of the European Union is to establish a one-stop shop for data protection with a consistent set of data protection principles applying across the EU. The GDPR has direct effect, so it applies to each member of the EU without the need for local legislation. The regulations significantly increase the potential penalties facing companies. The maximum penalty for breach of the GDPR is going to be 20 million euros, or if higher, 4% of a company's worldwide turnover. This is compared to a maximum penalty of $500,000 under the Data Protection Act. The GDPR will apply to all areas where companies process personal data. However, employee data is particularly affected for a number of reasons. Businesses often process more data on their employees than other groups. For example, information on websites visited, CCTV of them entering the business, keycard access to lifts and floors. The data held by employers on their employees is also usually unstructured. For example, the body of an email might contain personal data about one of your employees. If you compare that, for example, to a credit card company, which collects significant personal data, there much of the data is likely to be held in a kind of predefined structured format. They might have, fields on a screen. So this can cause particular problems when you're limiting the data that you hold or when handling a subject access request. Also, whilst customer and supplier disputes are relatively common, a dispute with an employee can really be quite personal and directly relevant to personal data. So, the GDPR takes a similar overall approach to the Data Protection Act and sets out a number of principles for the processing of personal data. Terms like personal data, processing, data controller, and data processor will hopefully be familiar to you all. A data controller, for example, one of your companies, must ensure that it can meet at least one condition providing the legal basis for processing. At the same time, you must give employees, who are the data subjects, information on these purposes. Data subjects have a number of rights, such as a subject access right to obtain information on how their data is processed. While similar to some of the obligations you already have under the Data Protection Act, compliance will require increased granularity, so you've got to have a lot more detail, an increased emphasis on the legal basis for the data processing, even more detailed policies and information. I'm sure you're happy to hear that, lots more policies, and additional rights for data subjects. And the problem being that non-compliance risks you being penalised with those large fines that I talked about before. The issue of transparency runs like a thread through the GDPR. Previously, data had to be processed fairly and lawfully, but the GDPR adds this concept of transparency. So in the context of an employer-employee relationship, this means openness and explanation. So for example, when responding to a subject access request, it's prudent for you to explain how you approached responding to the request, not just provide the requested data. Obtaining consent from an employee is one of the methods by which an employer can establish a legal basis for processing personal data. And Article 7 of the GDPR sets out some stricter and more detailed conditions over when consent can be used. So consent has to be freely given, specific, informed, and unambiguous. So consent is not freely given if there is no genuine free choice. At the moment, the majority of employees probably obtain consent for processing personal data using standard provisions in their employment contracts. This is really a kind of take it or leave it basis. If the employee doesn't accept it, well, they haven't got a job, they don't start the job. But in that kind of scenario, an employee has no real choice. So in future, the contractual consent is unlikely to be effective under the GDPR. The onus is now on an employer to show the employee gave consent. If you get consent by means of a written declaration, the request must be made in a manner that's clearly distinguishable from other aspects of the document. If it's incorporated in employment contract, you should really be getting the employee to use a separate signature box. And the employee has the right to withdraw consent at any time and must be told of this right. It must be as simple for an employee to withdraw consent as it is to give it. So consent can be useful in one-off scenarios. For example, if you had to send medical information to a doctor or a life insurer on behalf of the employee, but it's now going to often be impractical and ineffective in a day-to-day employer-employee situation. So what you need to do is consider other grounds on which you can justify processing of personal data. And Article 6 sets out that you can process personal data without consent if it's necessary for a number of reasons. And we'll have a look at those. Well, the first one is really if you've got a contract with an individual, for an example, to fulfill obligations under employment contracts. This also includes steps taken at their request before entering into the contract. You can process data if there's compliance with a legal obligation. So if you're required by UK or EU law to process the data for a particular purpose, you can. If there are vital interests, you can process personal data if it's necessary to protect someone's life. So this could be the life of the data subject or someone else. If you need to process personal data to carry out official functions or a task in the public interest, and you have a legal basis for processing under UK law, you can. I'm not sure whether that would apply to any of you on this webinar, but we can help and look into that if necessary. And also you can process personal data without consent if you have a genuine and legitimate reason, and that can include a commercial benefit, unless this is outweighed by harm to the individual's rights and interests. So I think that's legitimate interest is one of the ones I think most of you might be using going forward, along with the contract that you have with the individual that will allow that. So the Information Commissioner's Office has published some draft guidance on using consent in March 2017. It's available on their website. The final version, I understand, isn't out yet, but should be published later this summer. So employers are currently required to provide job applicants and their employees with a privacy notice. This is called also known as a sort of fair processing information. And this sets out the purposes for which data is processed and further information to ensure processing is fair. Under Article 12 of the GDPR, all information provided must be concise, transparent, easily accessible, and given in plain language. You must also provide information on the legal basis for processing. As previously mentioned, in an employer-employee relationship, I expect the legitimate interest condition will be the most commonly relied upon condition. If it's used, then the employee must be told what the employer's legitimate interests are. So you've really got to kind of explain those interests to your employees. In addition, you're now also going to have to explain to the employee the source of any data, unless that comes directly from the employee themselves, who will receive the personal data, or the categories of recipients. For example, you might provide it to future employers, payroll providers, etc. The period for which the data will be stored, or if that's not possible, the criteria used to determine the period. The existence of the employee's rights, including to access, rectification and erasure. The right to object to processing on grounds related to an employee's particular situation. The right to withdraw consent if you as an employer are relying on consent, which you may or may not be. The right to complain to the Information Commissioner, and the legal basis for transfer of any data outside the EU. So that's of particular interest to anyone on this call who has overseas entities. Maybe you have your HR department actually in the US. Well, you need to look at that in quite a lot of detail. So this is a significant increase in the amount of information which you as an employer must provide. Still not clear how you're going to be able to balance the level of detail required and also the obligation I spoke about before to provide information concisely, accessibly and in plain language. How you balance the two is going to be very difficult. I expect though the Information Commissioner is going to provide additional guidance on this in the next few months. So the GDPR also extends employees' existing data rights. In addition to the subject access right, there's a package of rights that have been kind of best summarized as delete it, freeze it, correct it. And we're going to look at these in a bit more detail soon. The data subject access right in Article 15 of the GDPR is broadly similar to the right under the existing rules. However, employers will be required to provide some extra information, including the envisaged period of storage, details of the delete it, freeze it, correct it rights I just mentioned, and the safeguards applied on any third country transferred data. So employers currently have a compliance period of 40 days to respond to a subject access request. This is going to be replaced with an obligation to comply without undue delay and within 1 month, with an extension of 2 additional months if necessary, taking into account the complexity of the request. Given really the complexity of most subject access requests that you get in a kind of normal employment context, it seems likely that the new period for compliance will be up to 3 months. Good news. So from 40 days up to 3 months. Also, the £10 fee under the Data Protection Act is going to be abolished. However, where a request that you received is manifestly unfounded or excessive, you're going to be entitled to charge a reasonable fee, taking into account administrative costs, or you might refuse to act on the request altogether. This is a significant beneficial change. What is manifestly excessive will depend on the specific circumstances, but it's likely to discourage onerous requests. In many contexts, a person making such a request might not actually appreciate the scale of the work involved in responding. Again, I expect to see more guidance on what is manifestly excessive from the Information Commissioner. As well as subject access requests, an employee has a new package of rights which include the right to rectification, the right to erasure, so that's the right to be forgotten, the right to restriction of processing, the right to object to processing. The circumstances in which these rights can be exercised vary quite widely, but generally they're triggered if there's a breach of the data protection principles. The right of erasure may be exercised where any of the following apply. The processing of data is no longer necessary in relation to the purposes for which it was collected or processed. Data has been unlawfully processed. The employee objects and the employer can't show some overriding legitimate grounds for continuing with the processing. The right to rectification arises where data is inaccurate or incomplete. The right to restriction of processing, so the freezing request arises where processing is unlawful, data accuracy is contested by an employee, or an employee has objected to processing based on legitimate interest, pending a decision as to whether or not you have such a legitimate grounds. So they can ask in that time period for it to be frozen. There are quite a few scenarios where I think this might be used in employment disputes. So many, for example, perhaps most emails really aren't necessary for the purposes for which they were first produced. An email inviting an employee to a meeting, might be a kind of a grievance meeting, is really kind of quite ephemeral. You know, it was there for a particular purpose. However, it could still be personal data. Although there's no reason to keep that kind of meeting request email, I don't think anyone on this call has the time necessary to review it and decide on deletion. So if privacy notices are defective or reliance has been placed on, kind of ineffective consent, processing might be unlawful. An employee faced with a disciplinary allegation based on some kind of covert investigation, you going through their emails, may seek to freeze processing of data on the basis that his or her rights to privacy trump the employer's legitimate interests. The manifestly unfounded or excessive rules referred to in relation to subject access requests will also apply to these rights. If delete it, freeze it, or correct it requests are clearly excessive, you'll be able to refuse to act on the request or perhaps charge a fee. But I think in each scenario, you would have to look at the particular details, the facts, the kind of factual matrix, what's going on, and say whether you can refuse to provide the information or to refuse. An employer, as a data subject, as a data controller, has a duty to comply with various data protection principles. But the GDPR also requires you to be able to demonstrate compliance. So it's not just duty to comply, you have to demonstrate, you have to be seen to be whiter than white. So in principle, the Information Commissioner, and conceivably even an employee, may require you to implement technical and organisational measures and to show that it complies. It will not be sufficient anymore to say we're not in breach, you'll have to demonstrate such compliance. So where proportionate, the GDPR requires implementation of data protection policies, which is an organisation or technical measures. This is unfortunately likely to lead to a proliferation of new policies. If challenged, I think it's going to be better for you to be able to say you've got a policy with which you've complied, rather than saying, well, we haven't breached anything. Employers are also going to be expected to take steps to build data protection into system design. Subject to what is technically practical and cost, you'll need to be able to build in safeguards to comply with the rules. Measures must be taken to minimize what data you collect in the first place, ensuring it's necessary for the specific purpose for which it was obtained. Where you're maybe contemplating a new HR system, financial system, payroll system, it's advisable to consider what extent data protection can be built in, really just to simplify your lives going forward. Employers might be using data processors in a number of contexts, for example, banking, payroll. The GDPR tightens the rules on the use of data processors, extending the formal contractual requirements needed between data controllers and data processors. The processor may only process personal data if it has documented instructions from the data controller. It must ensure data security, and you'll have an obligation to demonstrate compliance to the employer and to permit inspection and audit. So not only are you under an obligation, but the data processor you use. At the moment, only data controllers, so you, have liability to data subjects, your employees, for compliance. Under the GDPR, data processors will also have a duty to comply, and they might also be potentially liable if they fail to do so. The role of a data protection officer is to advise employers of their legal obligations, monitor compliance with the GDPR, and with data policies and related training, and be a point of contact with the regulator. A data protection officer should be independent, with a position in some ways analogous to an auditor, but they are entitled to be employees, contractors, or consultants. How you balance this out with kind of the role of independent role and being an employee is a difficult one, but I'm sure it's one that can be sorted out, and again, more guidance coming from the Information Commissioner. Although some companies will appoint data protection officers voluntarily, there's only a requirement for a controller to have a data protection officer if its core activities involve systematic monitoring of large-scale processing of personal data. For example, health data, criminal records, if you're an insurer, potentially if you have claims information, or if you're a public body. If you're a public body, you've got to have a data protection officer. So having one is not mandatory unless you kind of tick various boxes. The GDPR places new obligations on companies in relation to data breaches. This is a move towards the US model of notifying breaches to the regulator and those effective. So what is a personal data breach? Well, Article 33 helpfully defines it as a breach of security leading to the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of personal data. So, for example, sending an email to the wrong person or leaving a laptop in a restaurant could both be breaches of personal data. One would seem to me much more extreme than the other, just using someone's wrong email address from some kind of autocorrect that you've been using, but that could be the same as leaving a laptop in a restaurant. On discovering a personal data breach, employers must notify the Information Commissioner promptly and within 72 hours if feasible. If the notification isn't made within this time, you must provide a reasoned justification explaining the delay. However, there is a bit of good news. The notification requirement does not apply if the breach is unlikely to result in a risk to data subjects. So that's unlikely to result in a risk to data subjects. For example, because all data on a laptop was encrypted. So if you did leave that a laptop in a restaurant, on a train, somewhere else, if it's all encrypted, you might not have to report it. In notifying a breach, an employer must describe what happened and set out the approximate number of individuals affected, the likely consequences, and the measures taken or proposed. If there's a high risk to a data subject, they must also be told. So the individuals affected, the person whose record it is on that laptop. Records must be kept of all data breaches and action taken, including those in respect of which there was no obligation to notify the regulator. So if you did leave that laptop, people could have been affected, but it was all encrypted. If you make the decision that we don't need to notify the regulator because the risk is relatively low, you should still keep a record of that. Although not all breaches are serious in their impact or need to be notified, the 3-day time frame means that you'll have to have in place clear policies on how you handle a breach with defined roles fulfilled by individuals who understand what they're doing. So you need to flow this down throughout your organization, that people understand that if they lose a memory stick, laptop, send an email incorrectly to someone, they do need to report this up, and that someone further up makes the decision of whether it's notifiable to the Information Commissioner. So with under a year to go, I hope I haven't scared you too much. You might already be well into planning your response to the GDPR, or you might have just started. Either way, here are some steps which I think you can take now. These are some of the ones recommended by the Information Commissioner, some of the ones I've kind of thought up about. So you should be identifying all existing data systems and the personal data processed. Consider setting up an information asset register, understand the legal basis for processing your data, and identify what will need to change to comply with the revised regime. Ensure the resources to prepare for change have been allocated. It may well be that you don't have at the moment the proper resources. My tip is sort of gently remind your boards about the potential fines just sort of to remind you of those, they're up to 20 million euros or higher, could be 4% of the company's global worldwide turnover. Compare that to the £500,000 you could be fined now. Not only about the fine, the Information Commissioner loves to name and shame. So your name will be on the Information Commissioner's website. They'll probably issue a press release about it. It will be in whatever press is relevant to you. Identify who takes overall responsibility and ensure that they have the time and support to plan for the reforms. Consider whether you should be appointing a data protection officer, but remember, it's not mandatory in all circumstances. Review your privacy notices and other fair processing information given to employees and job applicants. Consider what additional information will need to be included. For example, what legitimate interests underpin your processing? How long are you going to store data? And assess whether the business uses consent to justify processing at the moment, and if you need to move to something else. Consider relying on other routes, such as the legitimate interest grounds, or that processing is necessary for performance of the employment contract. Review contracts of employment, handbooks, and policies, and see whether and how they deal with data protection. Establish like a really clear policy on data breaches and make sure everyone really in the organisation understands that. Maybe have small working groups, have some internal training sessions. Try to obtain a full picture of exposure to potential data breaches by ensuring that breaches and loss are reported to whoever's responsible. As I mentioned just before, train staff on data protection responsibilities, how they are affected in their job, and develop and implement a policy on retention and storage of data. I've tried to set out on this slide here, the resources slide, some useful resources. It's worth having a look through the actual text of the GDPR itself. I know it's very long, but it just gives you a flavour of how much detail the regulator's looking for. I've also put up here some very helpful guidance notes which have been produced by the Information Commissioner. I think they've produced them in as much sort of clear, plain English as possible. They're going to be publishing more information in the coming months, so I would highly recommend that you keep an eye on their website, subscribe to their emails. They do provide some useful information. I'm going to be giving, and other colleagues are going to be giving further talks in due course on GDPR. I'll be sending out updates as and when we get more information on compliance, tips, things that we've seen, and further guidance from the Information Commissioner. What we'll also be doing is other webinars in the next few months. This one has been obviously aimed at you as an employer with employees. We're going to look at supply chains. We're going to look at things like data breaches in more detail. So if you're interested in that, you should hopefully after this webinar receive further updates and further dates when those webinars are taking place. And we'll also send out to everyone who's on here, and there's quite a few of you, thanks for taking part. We'll be sending out the slides from today's webinar, so you don't, if you haven't been able to take down all the notes, those will go out to you. Thank you very much, everyone who's taken part. We're pretty much hitting the deadline of when I said this would finish. So I see there's a number of questions. What I'll do is I'll respond to those questions afterwards and circulate everything to everyone who's taken part. If any of you got any further queries, my details are currently on the screen. I'm always happy if you want to pick up the phone, drop me an email, and I'll come back to you as soon as possible. Thank you very much, everyone.